USPTOs, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 U.S.C. Section 3 to advise the President on matters of national security.
The committee has read all 2,800 and can opine on what he saw as the ratio. Recognize the gentleman from Maryland.
Mr. Chairman, thank you. Director Squires, how did you come to file those trademark applications for the Board of Peace?
Thank you for the question, Congressman. We came to file, I had them filed in response to a immediate cybersquatting land grab of the domain name. And for those who are unaware of the term cybersquatting, it's like identity theft.
So were you acting as a lawyer for the Board of Peace at that point?
No.
So in what capacity were you acting?
Well, the Board of Peace, this is exactly the issue, and I'm glad to have the opportunity to explain it and respond to your letter. The Board of Peace has not yet been formed as an international organization. And the cyber squatters, 8 minutes into the President's speech announcing it, registered the domain name. And so
is it a public entity, the Board of Peace, or is it a private entity?
At this point, I'm not sure if it's formed or not. We acted as a custodian so that they could have the mark.
How did you come to act as a custodian for that trademark?
Under 35 U.S.C. Section 3, it's my responsibility to advise the President through the Secretary of Commerce on matters of national security and all matters of intellectual property. So
the Board of Peace is a public entity? It's a governmental organization, even though Congress has not created it? Is that right?
Sir, I don't know the status of whether it's an entity formed or not.
Okay, well, how did you get involved in it? Did the President call you about the cyber squatting incident?
No, the President did not call me. It came up through several organizations about the cyber squatting, and the action needed to be taken to address the harm.
When you talked about the cyber squatting, you noted that there were lots of other organizations that were already using some variation of peace organization, peace committee, world peace, and so on, right? There are dozens of them. I mean, I found them this morning just on the way in.
Well, again, you know, reference was made to Shakedown. This was registered, this particular boardofpeace.org, and without that, you don't have the ability.
You registered that?
No.
Oh, who registered?
A cyber squatter did. I mean, 8 minutes into the
But you don't have to talk about a cyber squatter. There are dozens of other groups that have peace in their name. Right? Well, look, where does your legal authority come from to file trademark applications on behalf of this Board of Peace, whether it's a public or private group?
It comes from the combination of 35 U.S.C. 3 and 35 U.S.C. 2 under the Lanham Act and in your opening statement.
Well, wait, do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump?
This was to protect the name Board of Peace as the entity gets booted up, to act as a custodian in a very narrow capacity with a bona fide intent to use the name, and then it's a intent to use application.
Who has the bona fide intent to use it?
The USPTO.
The USPTOs, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 U.S.C. Section 3 to advise the President on matters of national security.
So this is a matter of national security? Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon...
the website says $350, is that right?
Generally, yes.
It's not expensive, okay. And my... one of the able lawyers on my staff just passed me this, you filed a petition on January 21st, 26 to waive that fee for the Board of Peace, Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also the trademark office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
Well, your signature, as I'm reading it, you filed this on the 21st, and then you approved it on the 22nd.
Well, I would like to see the document to which you're referring.
Okay,
but,
we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation.
Okay,
but I do believe it's in
your
my authority.
Signature.
Yeah.
Okay, it was approved by Dan Vovanisi, but your signature is on the petition. And I guess,
yes.
Why did you request that waiver of the $350 payment for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted
Okay, and then
by someone
finally,
else.
you know that the Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. So were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So, I mean, that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I get another company to apply for a trademark for me? What's the answer to that?
If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
I'm, again, directing you back to USC 35 USC Section 3, where it's the Undersecretary of Commerce and Director of the Patent Office shall advise the President on national and certain international intellectual property policy issues.
Those are matters of public policy. They're not questions of representing the president before the Trademark Office, which obviously creates a stark conflict of interest.
The gentleman's time has expired, but you may answer.
Sir, I was not representing the President of the United States in this regard. I was representing filing an application to address the cybersquatting issue under my authority under 35 USC.
I appreciate it. Thank you. I yield back, Mr. Chairman.
Thank the gentleman.
All right, folks, I just watched a clip from a congressional hearing, and let me tell you, this is one of those moments where Washington politics gets messy real fast. You've got lawmakers grilling a federal official about trademark filings connected to something called the Board of Peace, and the questions started flying about who authorized what, who paid the fees, and whether the government crossed the line. And as someone who believes in transparency and accountability in government, this kind of exchange is exactly why these hearings matter. But before we dive into the details, welcome back to Straight Talk Politics, the place where we cut through the noise and talk about what's really going on in Washington. If you believe in honest conversations about politics, go ahead and hit that subscribe button, like this video, and drop a comment below telling me what you think after you hear this story. Your voice matters, and this channel is all about giving everyday Americans a place to speak up. Now let's talk about what happened in this hearing. A congressman started questioning a government official about why trademark applications were filed for something called the Board of Peace. According to the official, the reason they rushed to file those trademarks was because of what's known as cybersquatting. That's when someone quickly grabs a domain name or brand name online, usually to sell it later or cause confusion. The official claimed that within minutes of a presidential announcement about this Board of Peace, someone had already registered the domain name tied to it. So the argument from the government side was simple. They needed to protect the name before opportunists could exploit it. Now on the surface, that sounds reasonable. Cybersquatting happens all the time. If someone announces a new organization, business, or initiative, people rush online to grab domain names and trademarks, hoping to profit later. But here's where things got interesting. The congressman asked a simple but very important question. What exactly is the Board of Peace? Is it a government agency? Is it a private organization? Has Congress authorized it? And the answer from the official was basically, we're not sure yet. Think about that for a second. A trademark application was filed for an organization that doesn't even technically exist yet. Now, the official said they were acting as a custodian of the trademark, basically holding it temporarily until the organization is formally created. But that raised another big issue. The congressman asked, if the government can do this for one organization, can they do it for anyone? If a regular American wants to start a group and protect a name, can they just call the federal government and have them file the trademark? And of course, the answer wasn't exactly clear. Then the hearing took another turn. The congressman pointed out that the standard trademark filing fee is about $350. That's the fee every business owner, entrepreneur, and inventor in America usually has to pay when filing through the Patent and Trademark Office. But in this case, that fee was waived. A petition to waive the fee was filed and then approved the very next day. Now, the congressman raised the obvious concern. The same office involved in filing the petition was also involved in approving the waiver. That's where the words conflict of interest started getting thrown around. And look, as someone who believes in limited government and fairness under the law, this is exactly the kind of situation that deserves scrutiny. Government officials should never appear to be giving special treatment to anyone, whether it's a political ally, a corporation, or even something connected to the White House. Now, to be fair, the official insisted he wasn't representing the president personally. He said his actions were purely about protecting intellectual property and preventing cybersquatters from exploiting the name. He also pointed to U.S. law that requires his office to advise the president on intellectual property matters. So from his perspective, he was simply acting within his authority. But here's the broader point that conservatives and honestly Americans of all political beliefs should care about. Government power must always have clear limits. When agencies start operating in gray areas, filing trademarks for organizations that don't exist yet, waiving fees that everyone else has to pay, and making decisions that look like they benefit political leadership, people are going to ask questions. And frankly, they should. Accountability is not partisan. Transparency is not partisan. These hearings exist so that officials have to explain their decisions to the American people. And honestly, the congressman in this exchange was doing exactly what elected representatives are supposed to do, asking tough questions and demanding clear answers. Now, whether you think the official handled the situation properly or not, the bigger takeaway is this. Government actions should always be above suspicion. If something is legitimate, it should be easy to explain. If rules apply to the public, they should apply inside the government too. That's the standard Americans expect, and it's the standard we should keep demanding. So now I want to hear from you. Do you think the government was right to step in and protect the Board of Peace trademark from cybersquatters? Or do you think this looks like a case of government officials bending the rules? Drop your thoughts in the comments below. I read them, and I love seeing the debates you guys bring to this channel. And if you want more breakdowns of major political moments, congressional hearings, and the stories the mainstream media sometimes glosses over, make sure you subscribe to StraightTalk Politics, like this video, and share it with someone who wants the full picture. Thanks for watching, and I'll see you in the next one.